you'll see my presentation is practical tips and tricks for drafting commercial contracts. I don't know how you find these things, but I've tended to find if you go to training, sometimes like this, you're lucky if you come away with one or two things that you can use. I remember going to an all-day training session, it cost me $750, which I paid for out of my own pocket. And the one thing that I actually took away from that was the note up function in Ostly, which is where if you read a case or I think it's just a case of piece of legislation, there's a button you can push for note up, and it tells you journal articles and things that may have discussed that case. So that's what I got for my $750. I'm hoping that, I'm sure it was one of Michael's conferences, and I'm sure these are much better value for money. But hopefully I can give you at least one thing that you can take away, and that's probably as high as I'm going to put the goal today. And hopefully part of that comes from the fact that this presentation should be largely telling you how to suck eggs. We as lawyers, I think should know how to draft, and hopefully a lot of these things are things that are rattled around your head already. I'm not going to do a PowerPoint presentation. I'm really going to sort of talk you through the Word document which you've got already. And the introduction says, and the reason I think this is important is I think law is a profession of writing. It's about words. It's about how we express ourselves, to communicate clearly and comprehend and understand clearly. And I often think, and perhaps there's been prejudice, but when I see some garbled piece of writing that someone sent, I think it reflects their state of mind and their ability to process and organise information. And maybe that's not always true, and maybe it's just because people are still dictating rather than drafting from the inside out on a computer, and you can sometimes see how you get the streams of consciousness. But I bet there are other people who think like me as well, and the way you write, I think, does reflect on you. And the other thing I put in my introduction is to draft like you're painting a picture. Contracts and documents are visual creatures, visual beasts. And it should be treated like that. It should be treated like a picture. Lots of white space, even tabbed margins. I find the automatic numbering and tabbing processes that are in Word don't make for a nice, neat document. Your headings tab separately from the words underneath, and so you end up, instead of 2 or 3 straight lines of text like a table, like my beautiful document, I hope, it'll give you multiple tabs. So the way it looks is important. So those are sort of 2 introductory remarks I made. And I'm going to give you, I've broken it down to 10 points. Maybe I've been spending too much time on Twitter or something, but the top 10 drafting tips from me. Here it comes. The first is structure. I think this is pretty critical, and you see it offended a lot. I don't know. These are my rules, so to me it's an offence. Which is structure and definitions. I think when you're drafting a contract, in your definition section, you should include only definitions, and you shouldn't include any operative sort of provisions that say, thou shalt do this, or someone needs to do this. And these examples I put up here are a little bit subtle, and they come from a LexisNexis document, Australian Encyclopedia of Forms of Precedence, and I find this is in there a lot, in their precedents. And if you look at the example additional charge means a charge in accordance with the consultant standard rates, in effect from time to time, payable by the customer. And it's those are the offending words, if you like, the payable by the customer. A consultancy services example is perhaps more overt. You've got consultancy services mean the services to be performed by the consultant. So the definition is telling you that these services are to be performed by the consultant. It's imposing the obligation on the consultant to perform consultancy services in the definition. And these are fairly simple and trite examples, and that's why it's in there. But what I suggest is, instead of creating an obligation to pay an additional charge, an obligation to perform certain services in the definition, what you need in your definition is additional charges means the charges set out in this item of the schedule, or consultancy services means consultancy services set out in this item of the schedule. And somewhere else in the body of the agreement, you'll have the operative provision that says the consultant will provide the consultancy services, or you will pay the additional charges. So the obligation to pay or provide comes out of the body, not the definition. the reason that's important is not only just for neatness and the painting like a picture, but when they do arise, you sometimes see it's doubling up on the operative provision, and it usually happens in a fairly harmless way, but you'll have the operative provision saying thou shalt do this, and it's in the definition repeated again. And when you're saying the same thing twice in a contract, you're inviting trouble. In the body of the contract, well, look, this clause is so long it barely fits on the screen. I like one sentence per clause, or subclause if you like. I think it makes things visually a lot easier. I think it enables a reader to skim through the document and actually read it. Now, this slab, you just cannot read and understand that slab without reading every word in the slab. It's, I don't know, Kath and Kim, where Kath does the speed reading with her hands, yeah? Look, I did that speed reading course that she's doing there, and there's actually some truth in it, because the speed reading mechanisms that they teach you are not actually about reading the sentence, but sort of swooping through it with your eyes. And that's actually very doable if you, and not that you do this with your clients' contracts and then charge them time for doing it that way, but it enables at least a reader to read it quickly. The thing that's particularly offensive about these two slabs, and these slabs were dished up to me by another lawyer. So just to put this in context some more, so I have a law firm. Yuha Legal is my firm. It's really just me, and the way I operate is I contract my services out to in-house legal departments. So I effectively attach to that in-house legal team could be for a project or a maternity leave cover, or could be part-time period, whatever. And so as a consequence, I'm stepping in and out of these in-house environments. I work in private practice too, and have some small clients, but often I'm wearing the in-house lawyer's hat. So as a consequence of that, I get nice invitations to cocktail functions once in a while and training and so forth. But I also get to instruct other lawyers in the big and medium-sized firms. And this is something that was recently dished up to me by a lawyer, slightly amended version. I've actually shortened it a little bit, by a lawyer in a mid-tier firm when we asked for some specialist advice on this thing. And the thing that's particularly offensive about these two slabs is the only difference from slab 1 to slab 2 is that one says the person will answer questions, and the other says the person will provide information and documents. And that's the only difference. And they've taken these massive 6 sentences. This is me, and hurriedly, I'm petrified. There's going to be errors in here somewhere, and someone will pull me up on it. But this is a same information, more clearly set out. It's one sentence. Admittedly, you've got a long sentence, and when you want to break it up, obviously you do the A, B sort of thing. But only ever one sentence. And if you want to make a provision that attaches to the first sentence, put it in another subclause and say, if such and such in clause 1, then this. And it just breaks it up, makes it visually very easy and very, very beautiful. It also encourages clarity of your own thought as well. If you need 3 or 4 sentences to ramble that out, you probably haven't expressed yourself as clearly as you could. The next structural tip I have is about schedules and the variables that you have in your contract. For me, I think you've always got to insert the variables in the schedules, never in the body. I think there is one school of thought that suggests that you should hide variables throughout the body of the contract, and I say hide deliberately, so that your client or internal client in procurement or whoever actually has to engage with the document somewhat and actually read the thing, because they're in there hunting for the commercial variables that they need, and so you sort of force them to read the document. At the same time, when track changes was sort of newish to me, I used to, in an in-house environment, I'd give people the amendments to be made and say, well, you should change word 6 to this, but I'd make them do the track changing because I didn't like track changes at that time, and that was my way of making them engage with the advice I'd given them rather than just sort of hitting forward. I don't think it's a good idea to do that. I think you're setting people up to fail, and I think every variable should be in the schedule. And this is an example, it's a real example from an in-house environment where their standard contract had all the variables in the schedule, except for this one, commencement date. It would say commencement date means insert date. And it was missed all the time missed. And in one sense, it made me feel superior because I was always able to pick up the procurement department and say, oh, you've missed the, this variable here. But it's not a fair setup. And I've seen real examples where the thing's missed, no data is entered, no date of the execution is there, so now you're going to parole evidence to try and find out when the commencement date was. So I think if you keep the variables of the schedule, it makes it easier for people to function with. The other thing it does, it enables the commercial person to take a good quick commercial snapshot of the agreement without actually having to read it. Again, it's a little bit deadly because they may misread it, but let's face it, most of these guys don't read what we do anyway. So it gives them a snapshot, as I say. Secondly, this is a very practical tip. Do the work. For me, I find I've always got to print and check on the hard copy. I mean, pity the trees, but it amazes me when I think I've got something right on the screen and you print it, you read it in hard copy, you made a mistake. It's different. You see it differently. There's something about the way we read on screen. I'm so anal. I do this with most emails that I send if they're of any importance, particularly when I'm estimating or quoting for work, or something like that. Or writing a hot political sort of email in an internal in-house environment, which they usually are. You're trying to create a paper trail or set someone up to make some decision. So I think that's well worth doing. In fact, in emails, I mean, early in my career I did a discovery matter, and we trawled through everyone's emails. And after that, I decided I'm going to keep my emails incredibly sterile because we found. Through this email trail, we're reading all the titillating examples of someone's affair that was taking place with someone else from the office in the workplace and sending them around the internal email. So mine are just absolutely sterile, no personality, no PS, and I keep my contracts the same way. Never, ever find and replace all. You're setting yourself up to fail there. Beautiful, tempting function. Problem with it is you get words like contractors and subcontractors. You find and replace all contractors with, I don't know, Telstra or whatever. All of a sudden your subcontractors are becoming sub-Telstra, and so it'll convert part words. You can manage that obviously with a replace whole words only sort of thing. The real setup is when you're using track changes as well. Find and replace all will sometimes go and replace words that you've eliminated and deleted with your track change, so it's out of the contract as far as you're concerned. But when you find and replace all, it will reinstate that word back in there. And again, it's just a discipline thing. If you find and replace, you're going through it properly, you will. You're making a decision rather than the computer doing it for you. Parties, you see this a lot, and I suppose 9 times out of 10 it doesn't matter really because it's clear. But for my part, I never ever use the word it's or they. When describing the parties, because I think you invite the opportunity for confusion. And the examples I've got here is, so prior to the provision of services, the contractor provided the principal all information and documents relating to the management of subcontractor safety, including but limited to its safety plan. And it's a slightly varied version, and I think what begs the question is it's about the subcontractor safety, and perhaps if it's a management of or subcontractor safety management, including its safety plan. You wonder, well, is it's about the contractor or is it's about the subcontractor? And the same concept applies here in the they. Prior to provision of services, contractor will provide the provincial with all information documents relating to the management of subcontractor, including but limited whether they are operating under. So is they the contractor is operating under such and such a policy, or is the subcontractor operating under such and such a policy? And you do see these ones sometimes where it's not clear whether it's is the principal or the contractor, and it makes you boring, and it creates incredible more repetition. But if you're talking about the principal, say the principal. If you're talking about the contractor, say the contractor. If you use it's, you invite opportunity for people to be confused about who it is that you're talking about. It doesn't happen much, but it does happen, and you don't want to invite it. Say what you mean. I think when you're drafting for the avoidance of doubt, if you've used the term for the avoidance of doubt, what you're really doing there is admitting the fact that you haven't drafted it properly in the first place, in your first sentence, and you've been unable to eliminate the doubt or create certainty in your original sentence. And you do see for the avoidance of doubts where you're still confused after the for the avoidance of doubt. So you're probably admitting yourself you haven't drafted it clearly and properly in the first place. For the avoidance of doubt necessitates a second sentence tacked onto the first one, so that offends my earlier rules I've done, I suppose. The other thing it creates is you're expressing the same thing twice. So you're saying blah, 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 and blah, 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 blah. So your original sentence and your second sentence can be interpreted in two different ways. And here's some avoidance of doubt examples. I won't read them. The first one, honest, I don't know whether it makes more sense or less sense with or without. It's a bad clause altogether. It's one I happen to find in my collection of things. So again, don't mean to be partisan with Snowball and Leap sponsoring, but that's a LexisNexis document as well. This second example is saying, our intention to trial other goods for the avoidance of doubt, this agreement is non-exclusive. Well, why is that for the avoidance of doubt point? I mean, just say this is a non-exclusive agreement. It doesn't establish any binding obligations. It's not even true for the avoidance of doubt. And the next one you've got for the avoidance of doubt, which is really a definition. It's it's an operative clause. It's saying our obligation to carry out the research is subject on us getting Commonwealth funding. We just say it. It's not really for the avoidance of doubt point. And note I find is very similar, and you don't see this one as much, but it's just as sloppy, I think. And this is an example where someone's used note, where it's a definition. It's someone's taking accredited training. Note, accredited training means, well, stick accredited training in the definitions and say accredited training means blah, blah, blah. And what you avoid there is the treasure hunt. Now, I want you to have to go hunting through the document for what the definition of accredited training or anything else is. It should be there in the definition section at the front or at the back. I don't know. When I'm dealing with sophisticated clients, I tend to put the definitions and interpretation section at the front. I don't know, it seems to be more the convention. When I'm dealing with less sophisticated clients, I tend to put it at the back because it seems to overwhelm them when you've got your interpretation clauses there. That's how I manage it. I don't think it matters as long as they're all together. Be honest, this is more about your negotiations with the other side. Tracking changes. I had a negotiation not that long ago with a lawyer on the other side, took it on themselves to make a correction. And it was as simple as, instead of saying blah blah clause 4.1b, they deleted the b and just made it 4.1. And they tracked a whole bunch of other changes in the document, but they didn't track that change. And that for me just gave me a big launch of paranoia of like, well, I've picked up this change they haven't tracked. What else haven't they tracked? If you're making changes, even if they're innocuous, even if you're correcting a typo in your document, you've got to track it and show it to the other side so they can see you're being perfectly transparent. And this slowed the matter down because I was looking for reasons to slow it down anyway, but it allowed me to go, well, you've done this, now I have to read every single word, can't trust you anymore, I thought we had a good relationship. A covering email can help with that sort of thing too, even if you have track changes. I find a covering email saying, these are the things I've done to your document, and if you're highlighting the significant things, it gives an air of transparency and helps the communication. Now, countering this be honest thing, this is, for me, probably about a limit. I don't know, I picked this up out, I think it was out of a Minter Ellison document or a Malice's document, I'm not sure. But you do see, and probably out of big firms, you do see sometimes people sneaking stuff in the definitions where it's quite a significant clause, and it's been snuck in the definitions as an operative type clause. Again, another reason to keep the definitions clean of operative clauses, so such things can't be sort of snuck in there. But this sneaking in, I didn't mind, and I've sort of adopted it, and it's a contra preferendum clause. And normally I think truly the contra preferendum clause should go back a bit boilerplate saying, shouldn't be construed against the drafter. But I find this one, it's an interpretation type thing, and I don't mind sneaking that in with all my other boilerplate interpretation type clauses and say, rule of construction doesn't apply against me because I've drafted this. And to be extra sneaky, I make sure it's the second to last one rather than the last one, so it doesn't show up. So, no, in bending the honesty factor, that's about as far as I go, but I think that's okay. Again, when you're dealing with the other side, consider the mutuality, consider what you put in your contract, you could sometimes expect to be asked back of you. And depending on the negotiating power and the nature of the transaction, you want to think about that before you ask for it, I think, sometimes, whether you actually need it and whether if it's asked of you, whether you can provide it back. Exclusivity is an example. I think if a contract is exclusive, say it's exclusive. If it's not exclusive, say it's not exclusive. I'm talking in the context of supply sort of contracts here, which I do a lot of. That reduces confusion. But if you're asking for exclusivity, don't be surprised if the other side asks for that back. Similarly, limitations of liability and exclusions of certain types of liability. And it surprised me dealing with the large corporate ones, I don't know, a couple of years ago. They were the customer, and they were putting in for the supply of goods, and they were putting in their contract that they want to exclude all liability for indirect and certain types of losses and limit their liability. And will just invite, so obviously the supplier, who's got more reason to ask for such limitations and exclusions, to put them back on them and say, well, we want an exclusion, we want a limitation as well. And seeing as you've given yourself one, it's only fair that we should get one too. So it made it very difficult for them to reject that sort of thing. I think indemnities are similar. They don't always necessarily give you a lot. And I've worked at some organisations, some companies that just refuse to give indemnities, but it's just part of their delegated authorities, but they would seek them off other people. And so obviously by seeking an indemnity off another person, you've invited them to ask it back off of you, they ask it back off of you, you can't give it, you've locked the whole negotiation up now for an indemnity that maybe you didn't need in the first place. Confidentiality is similar. Usually a confidentiality clause is okay, but in one of my contracts, or through the drafting I've done for Smokeball, I have drafted the world's greatest confidentiality clauses that cover everything, and I'm really happy with it. But it's not the kind of clause I would want mirrored back at me, particularly if I was the in-house lawyer, because it's got all those sort of things of particularly imposing positive obligations to help and destroy and do certain things and account for things. And these are things you might be happy imposing on someone else but not doing yourself. So think about that, because confidentiality is it's a pretty lukewarm thing that you could expect to be mirrored back at you. So make sure you're comfortable, well, either that you've got the negotiating power that's not going to happen, or you could resist it if it happens, but bear in mind that otherwise if you put something in, you could expect to see it back. Non-contracts, I don't know, contracts always sat very naturally with me. I did well at uni, I've always liked it. I know it's dry and boring, but I kind of like it. It's old as well, it's non-technical if you like. It's been around for hundreds and hundreds of years, you don't have the latest, well, a little bit of the trade practices stuff, unfair contracts, but you understand what I mean, it's stable. And one of the tenets obviously is certainty of contract, and one of those concepts that flows out of that is agreements to agree. You don't have an agreement to agree. You don't have an agreement that says, we will agree to this, because you can't. And this, well, I call it a jester clause, and I think this is getting close to that. And this is a clause, similar to a clause that came up in a matter I was working on for a client. And what it says is our contract's based on this exchange rate. The exchange rate goes up or down, by so much over this month period. We will meet and discuss. We may agree to change the price. So that's it. And this was some years ago. I deleted this. I thought it was pretty stupid because well, you can meet and change the price at any time. There's you can do that whenever you want. So we don't need this redundant clause. And at this time, I was kind of raging with the procurement department that was they just filled their contracts with all this rubbish. So I was out of that. Anyway, I had deleted that. Instructions were happy with that. Had a call in 6 months or a year later saying, "Where's that clause? Exchange rates have varied by this much in this period. Surprise, surprise. And we want to have a review meeting. We want to be able to point to the clause to be able to trigger it." No harm's done. They're able to have their review meeting anyway. But it showed to me, well, okay, even though it's what I would term a gesture clause, it said we'll have a review meeting. There's no obligation that flows from that other than to have the meeting. It can still be useful to have those things. So I don't like it, but there's a commercial purpose to it. I don't like it as a contract lawyer, but you can understand why business people want it. Drafting for uncertainty, one of the biggest and most constant examples you see on this is failing to account for GST. Is $1 million inclusive of GST or exclusive of GST? And that's an easy, well, one should pick that up all the time. And one usually does, but the thing I find challenging is when the client says, look, we won't say, particularly if you're the one potentially paying the GST, we won't say, we'll let it slide through, maybe we'll get away with it at the last minute and we'll just leave that conversation for when we have to have it, And you do see that a fair bit. Obviously, look, you take your instructions, you do it, but you've got to cover yourself and say, well, I've told you this is uncertain, you're laying the ground for a dispute. It's not the way I'd like to normally do things. And I would avoid doing that, but sometimes you're instructed to do it, so make sure you cover yourself. Keeping things simple. I drafted this contract once, which was just this masterpiece of multiple software licenses and various services and things like that, all wrapped up under this contract, and it was such that certain of the software licenses could be severed out and the other ones would continue, and the service, and it was a masterpiece. But in drafting the complexity of it, you almost then you have different staggered commencement dates and different terms. That you're really setting yourself up for confusion, mistakes, and worse still, even because it wouldn't happen to us obviously, but then the client takes it away and fiddles with it later and uses it for something else. So simplicity is always good. One contract per contract is generally a good idea. I thought after I went back and revisited this masterpiece after some time, I thought this is too much. And it's similarly in the masterpiece were embedded contradictions. Again, it was probably trying to keep the client happy. I mean, I was trying to fuse together a series of documents that they'd given me and trying to maintain those documents, and I dealt with the contradictions through precedent clauses, saying, well, this eliminates this, but it's just not satisfactory really, because someone fiddles with it and knocks out the precedent clause or changes the schedules around. The precedent clause is the sort of thing that a non-lawyer won't appreciate, so you leave a little ticking time bomb for someone there. So I wouldn't. Masterpieces are not good. I think simple is generally good. Mirroring people, obviously mirror your client. I've complained about the medium-sized firm that gave me back great slabs of text when I've given them this beautiful document. And it was a 3-page document with an execution clause on it, and when they'd redrafted it, it sort of became this 5-page thing with an execution clause hanging up of it. You need to understand what your client's going to use it for, and mirror their style. If they're trying to make a 1-page of T's and C's, you've got to keep it on 1 page. Those sort of things. Mirror your superiors. I think we've probably all learned that at a very early stage, because I guess they are your internal clients in a way. If there's a style that your superior uses, even if it cuts across my golden rules, you should use it. Mirroring the other side, I find difficult, but sometimes I suppose it's a good idea because you're not creating conflict just for the sake of it. So if you can mirror them a little bit, that can be useful. Being organised. I don't know if this is really organised. The comments, the comments function in Word. I don't know about you. I really dislike it. I think it's a problem. It doesn't show up well on the screen when you can miss people's comments in there, and it certainly doesn't show up well when you print the thing. And so I've had scenarios before I realised there were actually lawyers who used comments, where I've missed comment. I've missed this thing, and it's floated through various reiterations. I've missed what they're trying to say. So I wouldn't use it. It's big, fat, square brackets, caps. Stick it right in the document. Can't be missed. It's a flag there for anyone. That's what I use. Maybe bold, but I use that if you're making comments within the document or notes to yourself. Check this, discuss this, insert this, or here, whatever. Clause numbers and automatic numbering. I don't like automatic numbering. I pretty much disable all the automatic functions on Word and do it all manually. But I have done documents where I've used automatic numbering. If you're going to do it, you've got to do it properly and not just automatically number clauses 1 through 20. But if clause 20 refers to clause 11.1e, you've got to hook it up to 11.1e. So when clause 11 becomes point 12, it follows that and changes it and so forth. And there's a function in Word that will do that. Sorry, I meant to get it for you, but if you're going to use automatic numbering, do it properly. Otherwise, don't use it. And what I do now to help me keep track of clause numbers, I stick square brackets around my clause numbers. So I say, in the body of the text, clause 7, I put square brackets around the 7, so I can keep an eye on it, and if the clause has changed later, it sort of leaps out at you better, and you can do a square bracket search, and there's no problem in even letting it get executed in that form, I find. Folder system, you can, you'll see, sorry, I go to D, the document naming system I use for all documents, every single document I use, I name in this way, and it's date-based. So 2010, 8, August 12, the 12th of August when I did it, 13:30, I time code them. So at 1:30 I made this document, JL for UHA Legal SLC presentation. Create a system for it, and I find the time coding is very useful, because although Word or Microsoft will give you that when you go into your folder, it'll change as to when you've opened it and so forth, but it doesn't actually automatically organise the documents in that way. It organises documents alphabetically. If you time code your documents like this, you'll see your chronological history. It's like a correspondence file for yourself of your documents. And what's more, if you've time coded something when you've saved it at 1:30 and you go, well, gee, I wish I had the document from 12:30, and you go back to your 1230 version. So I time code everything. Whatever it is, you've got to have a system, and the folder system is similar. I think you can organise your information by dates, by subjects. You've got to have a system so you can find your things later. And especially as an in-house lawyer, that's half your function, is being able to find things that other people have lost. And it just helps your credibility in drafting, I think. And then backup. I use a function called Dropbox.com. Check it out. It automatically backs everything up to the ether for me all the time. You can use it on multiple computers, and I can pull down anything anywhere. I think it makes you be a better lawyer if you're organised, and a better drafter too, because you can, well, particularly for the negotiation, be quicker in the uptake when it's time to talk about things. I think that's pretty much all I have, and I've burnt my time. Unless anyone has any questions or comments or arguments with my ideas.
Are there any questions for Anthony? Would you join with me in thanking him?